My name is Lori Smith. I am the owner of 303 Creative LLC, a graphic design company that creates custom websites. I will design websites for anyone, including LGBT people, as long as the message of those websites does not conflict with my religious beliefs. Therefore, I will not create websites that celebrate same-sex marriages.
My name is Elenis. I am the director of the Colorado Civil Rights Division, the agency responsible for enforcing the Colorado Anti-Discrimination Act, or CADA. CADA forbids places of public accommodation, including Lori Smith's business, from refusing service to individuals based on their sexual orientation.
But I'm not discriminating against them based on their sexual orientation, just based on the message that their website is conveying. Therefore, CADA violates my right to free speech by compelling me to express messages that I disagree with.
I disagree. I think you are discriminating based on sexual orientation. But our opinions don't really matter at this point. Let's hear what the Supreme Court has to say.
I think you'll regret saying that.
I think you're right about that, Lori. The question we will be ruling on today is whether application of the Colorado Anti-Discrimination Act to compel an artist to speak or stay silent violates the free speech clause of the First Amendment. And our answer is
no.
Yes.
What? How did you make that decision?
Well, you see, the First Amendment prohibits states from compelling people to express messages that they do not want to express. We have seen in West Virginia State Board of Education versus Barnett that students may not be compelled to recite the Pledge of Allegiance. Similarly, Colorado may not compel Ms. Smith to create websites that express celebration of a same-sex wedding. Yes, public accommodations laws like CADA are an important tool for eliminating discrimination, but they are not immune from the demands of the Constitution. When the two collide, the Constitution must win. CADA cannot be used to compel Ms. Smith to create websites whose messages she disagrees with, including websites that celebrate same-sex marriages.
I dissent. Today, for the first time in history, this court allows a public accommodation to refuse to serve members of a protected class. Colorado's anti-discrimination law regulates conduct, not speech. Engaging in discriminatory conduct, as Smith is doing by refusing to sell the same wedding websites to same-sex couples that she would sell to opposite-sex couples, is not protected by the Constitution. Her speech is only being compelled incidental to a valid regulation of conduct, which is constitutionally permissible.
No. You are reimagining the facts of the case from top to bottom. She is discriminating based on the same-sex wedding website's message, not the same-sex status of the couple. That message-based discrimination is protected by the First Amendment. Without that protection, creative professionals would be forced to express all types of messages that go against their morals and values. For example, a gay website designer would be forced to create a website for an organization that advocates against same-sex marriage.
No, Ms. Smith is allowed to include whatever type of message she would like in her websites. If she doesn't want to sell wedding websites that contain language celebrating or endorsing same-sex marriage, she doesn't have to. If she wants to only sell wedding websites that contain biblical quotes stating that marriage is between a man and a woman, she may do so. But once she has chosen that product, she must sell it to both same-sex and opposite-sex couples alike.
But same-sex wedding websites are the product she doesn't want to sell. She does not want to create customized websites about same-sex weddings because those websites inherently celebrate marriages in which she does not believe. She is discriminating based on message, which is constitutionally permissible, not based on status. She will design other websites for LGBT people, including same-sex couples, as long as they do not express messages contrary to her beliefs. And she would refuse to design a website for a same-sex wedding, even if a non-LGBT person requested that website.
No, you cannot define your product in a way that excludes a protected class. Ms. Smith saying that she only sells wedding websites for opposite-sex couples is the same as a hotel saying it only has rooms for white people, or a headshot photo company only taking photos of men because they think women belong in the home.
Pure fiction. The issue here is that Lori Smith is being forced to express customized messages with which she disagrees. This is a fundamental violation of her free speech rights. Accordingly, the judgment below is reversed.
You rule, Supreme Court.
You suck, Supreme Court.